Today we're talking about everything you need to know to remove your conditions on your residency. We're going to talk about what you need to file, when you need to file it if you're jointly still married and in a good faith relationship, and what the situation would be if you're separated or in the process of getting divorced. If your green card is conditional, and you can typically tell this by looking at the expiration date on the green card and seeing that it expires 2 years from the date your residency was granted, you need to apply to remove conditions on this residency. Now, the timing, if you're still in a good faith marriage, requires you to file the petition to remove conditions, which is Form I-751, within 90 days of the expiration date of your green card. You have to pay the filing fee, which as of the date of the shooting of this video is $680. And along with the form, you need to include as much evidence as possible that you're still in a good faith marriage. That evidence is typically a continuation of all the evidence you submitted with your green card application if you're married to a spouse. So what would that look like? If you submitted bank account statements with your green card application or brought them to your green card interview, you would typically just bring a continuation of those bank statements. We would want to see like 2 years of joint tax filings if you filed jointly, evidence of trips. If you've had kids together, congratulations, you would include the birth certificates of those kids and photographs of your relationship. These are just some examples of additional evidence you would include. Now, when you submit this, there's a few things that could happen. If you submit enough evidence, there's a decent chance that your green card will be approved. Your 10-year green card will be approved without any interview. Another thing that could happen is you can get a request for additional evidence if you don't submit enough evidence. And then you'll have an opportunity to supplement your evidence. If you don't provide enough, they can eventually schedule an interview for you and your spouse to show up and convince the officer that you're still married together and living in a good faith relationship. Now, one important thing for anyone who files the I-751 petition to remove conditions is that when you file it before your green card expires, you're going to get an extension letter. It's a letter from USCIS that says we've received your $680 filing fee and your I-751 form, and that you can use this letter in place of your green card for the next 24 months. So let's say your green card's going to expire in a month and you file this form 1 month before, so within the 90-day deadline, you'll get this receipt notice that allows you to use it for employment purposes and to travel. You would need to bring the letter and your expired green card with you as you travel, and this will permit you to re-enter the United States. Now, let's look at the situation where you entered your marriage in good faith, but now you're either separated or fully divorced from your spouse during the 2-year period of conditional residence. First of all, if you are fully divorced and you have a final divorce certificate, you should not wait until 90 days before your green card expires to file the I-751 form. You should file it as soon as you have the final divorce certificate, and you should select, I entered my marriage in good faith, but it ended through divorce or annulment on the I-751 form. It's on page 3 in the basis for filing. It's the second box. Now, let's say you're separated, and this applies for both situations. So let's say you're separated but not fully divorced. This is actually a slightly more complicated situation because there's no option for this on the I-751 form. What I typically do in this situation, and if you're in this situation, you should speak with a lawyer. You shouldn't do this yourself, in my opinion. What I do is I will indicate that the marriage ended through divorce or annulment, even though there is no final divorce yet. And then I'll attach a small statement saying that we are beginning the divorce proceedings and we need a few months. What will typically happen is several months later, you'll receive a request for evidence asking for the final divorce certificate. And hopefully that gives you enough time to begin and finalize divorce proceedings. The only ways to proceed with the I-751 are with a final divorce certificate or if you're fully still in a good faith marriage and living with your spouse. And the good news is that the I-751 and removal of conditions can be approved in both situations. So that's positive despite the terrible situation you might be in if you're separated or divorced. Now, regardless of whether you are separated or divorced, you still need to prove that you entered the marriage in good faith. So basically, when we got married, it wasn't just for an immigration benefit. We were in a real relationship, but through no fault of our own, it just didn't work out. If you can prove this, you can have the conditions removed on your residency. The biggest mistake I see people make is filing jointly by just getting their spouse to agree to sign the form with them when they're actually separated and no longer really living together. This is a mistake. In this situation, I will typically advise people, like if there's no chance you're gonna get back together, if marriage counseling or whatever isn't gonna work, then begin divorce proceedings. Because the only way to remove conditions is to either be fully married or fully divorced. Removing conditions on residency isn't really designed to be a super complicated process. If you're still in a good faith marriage and you've been saving your evidence and you have the time to go through all the paperwork, then by all means, you shouldn't have a super hard time filing this form. But if you ever need assistance, just know that I'm available to help you throughout this process if you don't want to take any risks with any of the procedures. If you haven't remained in a good faith marriage, at this point, I would advise you to speak with an immigration lawyer because there will eventually be an interview, and it's important to create a really good record of your marriage, how it broke down. And I'll typically work with clients to prepare a really detailed affidavit, a sworn statement, explaining step by step everything that happened in a way that an immigration officer can easily understand. And then we will really, in a detailed manner, prepare for the final interview, which can be really far down the road. All right, guys, I'll see you next week for another immigration video.